Hello everyone. In the last 13 presentations, the first part of the Indian Evidence Act, consisting of sections 1 to 55, has been explained. Three bills, Bharatiya Nyaya Samhita Bill, Bharatiya Nagarik Suraksha Bill, and Bharatiya Sakshya Bill were introduced by the Home Minister in the Lok Sabha on August 11th. Bharatiya Nyaya Samhita is intended to replace the Indian Penal Code 1860, Bharatiya Nagarik Suraksha Sanhita to replace the Criminal Procedure Code 1973, and Bharatiya Sakshya Adhiniyam to replace the Indian Evidence Act 1872. These bills have been referred to the Standing Committee on Home Affairs to carry out consultations and submit its report. While introducing the bills in the Lok Sabha, it was stated that the Indian Penal Code 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act 1872 were made to strengthen and protect the British rule, and their purpose was to punish and not to give justice. The changes are stated to have been brought in both these fundamental aspects, and the bills are aimed at decolonizing the Indian justice system. As we have already dealt with the provisions in Part 1 of the Indian Evidence Act from sections 1 to 55 in detail in the last 13 presentations, it would definitely be of interest to know what the position of these provisions would be in the proposed Bharatiya Sakshya Adhiniyam. In this presentation, the changes that are proposed in sections 1 to 55 of the Indian Evidence Act would be explained. The remaining aspects would be taken up as and when parts 2 and 3 of the Evidence Act are taken up. In the Indian Evidence Act 1872, that is the old Act, short title, application and commencement are contained in section 1. Section 2 is repealed and the interpretation clause wherein the words or terms used in the Act are explained is contained in section 3. And these terms are arranged in a logical sequence rather than in an alphabetical order. In the proposed new Act, the title has been changed as Bharatiya Sakshya Adhiniyam. Section 2 contains the interpretation clause and it is titled as definitions. The words or terms explained are arranged in an alphabetical order. In the definition of the term document, the words and includes electronic and digital records have been added. In illustrations provided, an addition has been made pertaining to electronic record in clause 2(1)(c) of the bill. Section 4 of the old Act deals with the terms may presume, shall presume and conclusive proof. In the new Act, these terms have also been explained in section 2 at appropriate places in the alphabetical order. Sections 5 to 55 of the Evidence Act deal with relevancy of facts. Part 2 of the Adhiniyam, consisting of sections 3 to 50, deal with relevancy of facts. Sections 5 to 16 of the old Act deals with relevancy of facts under various situations like facts forming part of the same transaction, facts which are occasion, cause or effect of fact in issue, etc. Sections 3 to 14 of the new Act deal with the same provisions and they are verbatim reproduced from the old Act, including the illustrations to the sections. While sections 17 to 23 and section 31 of the old Act deal with admissions, sections 15 to 21 and 25 of the new Act deal with admissions, and the content and the illustrations in the new Act are just the same as that of the old Act. Section 22A of the old Act, which dealt with relevance of oral admission as to the content of electronic records, has not been included in the new Act. Relevancy of confessions in the old Act are dealt with under sections 24 to 30. Section 24 deals with confessions obtained by threat, inducement or promise. According to section 28, when the influence of threat, inducement or promise is removed, the confession would become relevant, and according to section 29, The confession which is otherwise relevant does not become irrelevant because of promise of secrecy, etc. Sections 22 to 24 of the Bharatiya Sakshya Adhiniyam deals with confessions. Section 22 is equivalent to Section 24 of the old Act, and Sections 28 and 29 of the old Act have been included as provisos to Section 22 in the new Act. Section 25 of the old Act deals with confession made to a police officer. Section 26 deals with confession made in police custody, and Section 27 deals with recovery of incriminating material at the instance of the accused and proof thereof. Section 23 of the new law includes the provisions of Sections 25, 26 and 27 of the old Act verbatim. Section 30 of the old Act deals with confession made by one accused and its effect on others tried jointly for the same offence. Section 24 of the new Act is equivalent to Section 30 of the old Act. In addition to explanation 1 which already exists, a new explanation 2 is proposed to be added, which says that a trial of more persons than one held in the absence of the accused who has absconded or who fails to comply with the proclamation issued under Section 82 of the Nagarika Suraksha Sanhita, that is CRPC, shall be deemed to be a joint trial for the purpose of this section. Sections 32 and 33 of the old Act deal with relevance of statements made by persons who cannot be called as witnesses. These provisions are contained in Sections 26 and 27 of the new Act, and they are verbatim the same. The relevance of statements made under special circumstances is dealt with under Sections 34 to 39 of the Indian Evidence Act. Sections 28 to 33 of the new Act, which deal with the said aspect, is verbatim the same as in the old Act. The relevance of judgments of courts of justice dealt with under Sections 40 to 44 of the old Act is covered under Sections 34 to 38 of the Sakshya Adhiniyam. But there seems to be a typographical error in Section 36 which mentions Section 31 instead of Section 35. While Sections 45 to 51 of the old Act deal with the relevance of opinions of third persons, Sections 39 to 45 of the new Act contain the said provisions. Section 39 incorporates Section 45 and 45A of the old Act. Section 41 incorporates Section 47 and 47A of the old Act, and the rest of the provisions are same as those contained in the old Act. Sections 52 to 55 of the Evidence Act deal with relevance of character of parties to a suit or proceedings. Section 53A, which has been inserted by the Criminal Law Amendment Act 2013, states that in a prosecution for a sexual offence specified therein or for its attempt, when the question of consent is an issue, evidence of the character of the victim or victim's previous experience with any person shall be irrelevant on the issue of such consent or the quality of the consent. The provisions pertaining to relevance of character are contained in Sections 46 to 50 of the new Act, and the provisions are verbatim the same as those contained in the old Act. The Indian Evidence Act is considered to be a well-drafted Act, and rules and principles contained in the Act provide for fair and equal opportunity to the parties to the suit or criminal proceedings to adduce best evidence and assist the court in delivering justice. Whenever it was felt that a provision was unfair towards a party, like the provisions pertaining to the relevance of the character of a victim in a sexual offence, amendments have been carried out to such provisions. Provisions have been inserted to meet the situations arising due to technological advancements like computerization. In order to deal with social evils like dowry death and dowry harassment, special provisions relating to burden of proof have been inserted in the Act from time to time. The Bharatiya Sakshya Adhiniyam proposes to consolidate and to provide for general rules and principles of evidence for fair trial. It can be seen from the above that except for a change in the number of sections because of clubbing of some provisions in the old Act, the content of sections so far discussed, that is, from sections 1 to 55, is exactly the same, including the illustrations appended to the provisions. The changes that are proposed to be made from section 56 onwards will be dealt with in the next series of law of evidence. Thank you.